Thank you very much. Good afternoon, everyone. We have three fine journalists with us today who I'll introduce in a moment. After their questions, we will open up questions to the audience, and you can come to this microphone that's set up right here and ask your questions. First, we have Charles Benson from TMJ4 News, Corey Hess from the Milwaukee Journal Sentinel, and Victor Jacobo from CBS 58 and Telemundo, Wisconsin. Please welcome them. I have a few words about our guest today before the panelists take over, and he will also make some opening remarks before their questions. Former Justice Daniel Kelly was appointed by Scott Walker to fill a vacancy on the Wisconsin Supreme Court in 2016. He served until 2020. After advancing from the primary on February 20th, Kelly is now seeking a full 10-year term as a Wisconsin Supreme Court judge during this year's general election on April 4th. Kelly received a bachelor's degree in political science and Spanish from Carroll University in 1986 and a JD from Regent University School of Law in 1991. From 1998 to 2013, Kelly was a shareholder at Reinhardt Borner von Duren. He was vice president and general counsel for the Kern Family Foundation from 2013 to 2014, and in 2014, he became a founding partner at Rogan Kelly LLC. Without further ado, please welcome Daniel Kelly.
Madam President, thank you so much for that kind introduction. Good afternoon. It is good to see all of you. I'm delighted to be with you here today, and I'm told that this meeting adjourns at 1:15, so I'll try to keep my remarks to about 45 minutes or so. And that should squeak in just nicely. I think we have an election before us that is like no other. And I think that's largely because my opponent is a candidate like no other. Now, I think it has become abundantly clear that she intends to place herself above the law if elected to the Supreme Court and use her politics to decide the cases that come before the jurists. And so as we approach April 4th, I see that we have a very stark choice before us. Will we continue to have the rule of law, or will we instead have the rule of Janus? The way I see it, there's enough room on the Supreme Court for the Constitution or my opponents, but not both. I'd like to take just a couple of moments explaining what I mean by this. So the rule of law is a deceptively straightforward and easy concept. It is the promise that we get to know what the laws require of us before we make our decisions. It's our ability to make sure our actions conform to the law. Now, that promise that we will always know what the law is beforehand, that we have notice of it, that fairly drives the way that we have structured our form of government. Because the way you preserve the rule of law is to make sure you separate the lawmaking function from the law adjudicating function. And that's why we have political discussions and questions that get resolved in the legislature, while the court is reserved exclusively for resolving legal questions. It can be accurately said that the work of the court is entirely downstream of the legislature. So the politics go on there, and then once those are resolved in adopting a law, that law then comes to us on the court. And the politics are all done by the time it gets to us. So our responsibility is to do one thing, and the people of Wisconsin have been abundantly clear about what it is. So I know that all the authority that we exercise in the court comes from the people of Wisconsin on loan through their Constitution. And in that, they've told us they have one job for us, just one. They say, please pay attention. Do this well, but it is just one job. Use the existing law to resolve the cases that come before the court, and that is all. They tell us they're not interested in whether we think it's a good law or an effective law, or whether we would have passed that law if we had been in the legislature. They just tell us, apply that law, period. And they tell us if they want to have a conversation about whether it should be changed, they have an entirely different branch of government for that, called the legislature. And so we keep those two functions strictly separate to make sure we can preserve the rule of law. Now that should drive what we talk about in our campaigns. And because I'm running for Supreme Court Justice, this is what I talk about. We talk about the Constitution, the rule of law, judicial philosophy, what it takes to be a good jurist. That's what I talk about because I'm running for a judicial position. My opponent, however, talks about politics. And that's virtually all she talks about. She talks about her values. She talks about how certain issues should be resolved should they come before the court. She talks about what she thinks the laws ought to be, what they ought not to be. And that's virtually all she talks about. Well, keeping in mind that we keep these functions separated, law making for the legislature, law applying for the court, if you didn't know better, you would think she was running for a spot in the legislature. So all she talks about are things that are not relevant to the work of the court. Now that creates some significant problems. Let's take a look at a few of them. 235 years ago, the framers were talking about this new constitution that they had developed and how it would function. And a number of them did a fair amount of writing about it. One of them was Alexander Hamilton. You guys know Hamilton, right? It's the Broadway star, rapper. Yeah, that guy. Turns out he talked about the courts. And he said, courts would be the least dangerous branch of government. Least dangerous. And he said that liberty would have nothing to fear from the courts. He said, but only so long as they only do the work of a court, using the existing law to resolve the cases that come before it. He said, however, if the court should ever combine its power with that of another branch of government, then liberty would have everything to fear. Now, as my candidacy shows, I talk about nothing but what the courts are supposed to do. But my opponent, talking about her politics, she wants to combine that power, the lawmaking power of the legislature, with the law adjudicating power of the court. And if Alexander Hamilton were here today, he would look at my opponent and say, liberty has everything to fear from you. Now we see that work out in some of the judgments my opponent has made. And I won't go through the laundry list of cases, but suffice it to say that there have been scores of cases that are problematic in their resolution on sentencing. And some of the most heinous crimes, brutal rapes, in which my opponent gave no prison time whatsoever, or very light sentences. Now, those sentences in themselves are problematic, but what's really chilling is the reasoning that got there. I hearken back again to Alexander Hamilton. He said the courts have neither the power of the purse nor of the sword, but merely judgments. Let's look at the judgment of my opponent. A man brutally rapes a woman, duly convicted, comes before my opponent for sentencing. She says, 1 year in prison and change. But that's not the worst part. The worst part was the reasoning. She looks at him during sentencing and says, I see in you a good man, to a rapist. And she went on to say, and I don't think that you are a danger to society. I don't know how that computes. I mean, I suppose, unless you're a woman who needs to sleep occasionally, then he was a terrible threat. Oh, and did I mention, the woman was his cousin. So not even being a family member was enough to stop him from this terrible crime. But my opponent looks at him and says, you're not a danger to society. And like I said, I could go through a whole list of cases. But she was called on these sentencing decisions 6 or 7 weeks ago. She's asked, would you do this again? Because some of these people went on to reoffend. One even went on to rape again the same girl he was convicted of raping before. And her response was to laugh. She literally laughed off the question and said, yeah, even knowing what I know now, I'd still do those light sentences. If a court has nothing but judgment, then it depends entirely for its efficacy on the honesty and integrity of the words spoken or written by that jurist, and the probity of the analysis. And I think there's something seriously wrong in her judgment. And that's played itself out outside the courtroom as well. And again, I won't go through all the specifics, but the ads that she is paying to be run against me are nothing but a dirty pack of lies. They're simply not true. Take one for instance. So she says, how could Justice Kelly, how could he represent someone who was accused of sexually assaulting children? And she left the implication that I had represented them at trial. And that simply isn't true. And anyone could look at the public record and see that it's not true. And yet, my opponent wants everyone in the state of Wisconsin to believe that I represented them through trial. So that's the lie piece of it. There's also a slander piece of it. So she says the only reason that he represented them is because he likes the kind of crime his clients were accused of committing. And that is preposterous. I'd even go so far as to say that is a truly stupid thing to say. And I mean that in every dimension of that word. There's no intelligence behind it, there's no reasoning, and there are no facts. Yet she says it anyway. So it's a slander against me, but not just against me. There's a slander against all attorneys who handle criminal defense matters, suggesting that all of them like the kinds of crimes their clients are charged with committing. Now, I've known hundreds of defense attorneys over the years, and I've yet to meet one who approves of the crimes their clients are charged with committing. It's preposterous. Now, I could go on, but I'd be in danger of getting to my 45-minute mark. I'm not going to do that to you. So with that, what I'm really interested in is what these fine folks are thinking and then what you are thinking. So thank you very much for giving me a few moments to speak with you before we get started here.
Again, thank you so much for taking the time. We really appreciate it. The Aaron Rodgers questions are further down the list, so hopefully we have time to get to those. But I want to talk about something you can talk about all day, which is the Constitution, and specifically separation of powers, which you mentioned in your opening comments. In North Carolina, the state legislature controlled by Republicans urged the U.S. Supreme Court to embrace what is called the independent state legislature doctrine, which would essentially impact the role of state courts and state constitutions in regulating district maps, as well as potentially federal elections like presidential and congressional ones. The doctrine is based in part on the U.S. Constitution statement that the times, places, and manner of federal elections shall be prescribed in each state by the legislature thereof. Now, in recent weeks, the U.S. Supreme Court has asked the state Supreme Court down in North Carolina to take a look at it again and has waited for that to happen. But tell me your thoughts on the independent state legislature doctrine, this theory, whether you think the jurisdiction of state Supreme Courts should be shared or given over to state legislatures when it comes to federal elections, or should the state legislature here in Wisconsin be wary of pursuing such avenues to amplify their power and reach?
Yeah, that's a great question. So a caveat first. So because I'm a candidate for the court, and because this is a matter that could potentially come before the court, I can't say specifically how I would rule and exactly how I would consider that law. But we can talk about the kinds of principles and the way we would approach it, right? So yeah, the independent legislature theory, the United States Constitution commits certain activity to state legislatures. And the question there is, when it says the state legislature, is it referring to the legislative function, or is it identifying a branch of government that has exclusive power to address that question? Now, the resolution of that is going to depend on the original public meaning of the terms of the Constitution. So we go back and we look at history. As I mentioned, 235 years ago, the framers were writing about how this Constitution would function. And so the place to start is, of course, with the text, and then look at the commentary from that time to understand how people would have understood that provision at that time. And then we would apply that. Now, the interesting part of this is the interaction between the legislature and the potential role of the courts. Now, as I've mentioned already, we have these branches to do entirely distinct things. The legislature for writing the laws, for resolving political questions, and then the court for resolving legal questions. Now, for instance, this of course comes up in the context of redistricting, which is a matter that is almost an entirely political act, which one might understand why the United States Constitution would commit that question to the legislature. But there are legal requirements that maps have to meet, right? So they have to have equal population. And here in Wisconsin, Article 4, Section 4 says that the districts have to be reasonably compact, and they have to be contiguous territory. And there's a few other provisions. And of course, then there's the Voting Rights Act. And these are all legal requirements that a map has to meet. All right, so now the question comes, the legislature writes the map, and let's say someone looks at the map and says, well, wait a minute. There are constitutional requirements for that map, and this map is not meeting those standards. Can I take this to the court to resolve the legal questions? Or do we have the legislature as the final arbiter of those legal questions? And so as we look at the way the Constitution is structured, it commits the judicial power to the judiciary, and it commits the legislative power to the Assembly and the Senate here in Wisconsin. So the question will be, does that commitment of powers, does that prevent a court from considering the legal implications of a map? Or does the independent legislature theory override that such that some piece of the adjudicatory function migrates from Article 7 to Article 4 so that the legislature can resolve it there as a final matter? But those are just some of the thoughts I think that will go into how to address and ultimately work their way through that question.
Hello. Judge Protasiewicz has talked a lot about her values when it comes to reproductive rights, and you've said that that makes her unable to be impartial. But you've written in your own blog that abortion takes the life of an unborn child, which would be your belief. So how is that different? Yeah.
So first off, just a slight tweak. I've never said that her statement of her values prevents her from being impartial. I question whether she is going to be impartial, right? Different questions. Whether she is committed to and capable of setting aside her personal views. So let's start with this. To do the work of the court is, in contradistinction to politics, is a three-step process. The first step is to recognize that every single jurist who has ever sat on a bench in a courtroom in the United States of America throughout its history has political views and personal values. We all do. I do. But the second step is committing to setting those aside to do the work of the court. And then the third step and this is the critical step, having a methodology by which you can actually accomplish that. So here's my methodology. In every case that I analyze, every case that I decide, and every opinion that I write, I start with the law that applies to that case, whether it's a constitutional provision, statute, regulation, common law, whatever it might be. You start with that, and those are the premises. And then you use rigorous logic to move from those premises all the way down to the conclusion. And at the end, you should be able to look back and see an conclusion to the premises. And if you can, that is your guarantee the conclusion is commanded by law and is not influenced by the jurist's personal politics or values. Now, I think that, especially for a race for the Supreme Court, it's exceedingly important, number one, that you understand that three-step process and that you have that methodology, and then that you prove that you do it. So I've already served you for several years as one of your Supreme Court justices, and every bit of work that I did is all in writing. That's why on my campaign website, and that's justicedanielkelly.com, by the way, I've listed every single opinion that I ever wrote as a Supreme Court justice, whether it's an opinion for the court, concurrence, dissent, because I want everyone in the state of Wisconsin to be able to look at the work that I've done and confirm for themselves that what I did was set aside my personal views to do the work of the court, to see that unbroken chain of logic between the premises and the conclusion. And I encourage everyone to do that. Now, here's the thing. With the opinions that I wrote them with all my bosses in mind. That's all of you and the rest of the people of Wisconsin. So I wrote them in a way that you don't have to be a lawyer. You don't have to have a legal background to access them. I write in plain language, and I strive to make it as clear as possible what that chain of logic is, going from the premises down to the conclusion. And so I know that I can set aside my personal views to do the work of the court, and the reason I know that is because I've done it. And the reason everyone else in Wisconsin can know that is because I've proven it, and it's in those opinions.
Thank you. Do you stand by those previous blog posts, though?
Well, this is, so the question is whether I stand by the previous blog posts, but a fair amount of those were expressing my political views, right? And this is one of the things that I don't talk about. And we go back to the question of what is the role of the court. And in a campaign, we should be talking about the things that are relevant to the work of the court. And we know without question that politics and my political views are completely irrelevant to the work of the court. Now, I understand that it is easy to try to put the court in a political box and address it as a political institution. It's easy to do that. And it's comfortable to do that because we all talk about politics all the time in our common affairs of life. But it's not a political institution. And so we can't talk about it in the comfortably political way. We've got to make sure that it stays outside that political box. And it's one of the reasons why I don't talk about my political views, because I want to remind the people of Wisconsin that these different institutions serve entirely different and distinct functions. Now, if I were to start talking about my political views, that would be no more relevant to this race than who I think the Packers' next quarterback ought to be. And you might notice I don't talk about who the next quarterback ought to be. It's not relevant to the position.
Justice Kelly, in your opening statement, you referred to the ads being run against you as a dirty pack of lies.
Yes.
Charles, can you put it up? She turned it off. So I'll start again. In your opening statements, you made reference to the ads running against you as a dirty pack of lies. Here's one of the ads that I got at my house. It's paid for by the Democratic Party. And it says Dan Kelly supports the Wisconsin law criminalizing abortions with no exceptions for rape or incest. So should voters know, is this the truth or a lie?
So the lie in this is that I have stated what I would do with that question. So that's a lie.
Should voters know where you stand on this issue if it's an important issue for them in determining who should be on the court?
Yeah. So let's query the question a little bit. Why would it be important for the voters to know my personal view on that question?
Because it's an important issue for them.
Yeah. So is it something that the court should be resolving, deciding what the laws ought to be?
Eventually, we'll head to the state Supreme Court.
But yes, but what will we do when it gets to the state Supreme Court? What will we do with that question? What's our function?
To decide probably where the 1849 law stands.
Okay, in relation to. So all right. So let me let you off the hook a little bit. So there is a case that is currently working its way through the judicial system, and it was brought by Attorney General Call. And in that, and I've looked at the pleadings. I haven't looked at them recently, so I don't know if they're still the same. Pleadings can get amended over time. But when I looked at them, the argument was a 1985 statute on the subject of abortion has repealed by implication the 1849 statute on abortion. So the question in that case is going to come to the Supreme Court not as shall we or shall we not have abortion in the state of Wisconsin, and it won't be shall we or shall we not have exceptions to a ban on abortions. The question will be, does one statute impliedly repeal a prior statute? That's a legal question. And we will resolve that the way that we resolve all legal questions. We'll look at the law, we'll look at the principle of repeal by implication, and we'll decide whether it did or not. That's the way that we resolve questions that come before the court. We don't do policy questions. So if this goes to the legislature, the type of question that would be pending before the legislature would be, shall we or shall we not have exceptions to a ban on abortion? Or even, shall we have a ban on abortion at all? And then representatives from around the state would combine their knowledge, their background, their experience, and their wisdom, and they would hash out that political question. And eventually they would come to a decision, because that's the authority the people of Wisconsin have loaned to those in the legislature. So let's say that the people in the legislature adopt a new abortion statute. And the question comes before the court, and it is there for us to apply. My commitment is going to be exactly the same as on every other legal question and every other law that comes before the court. I will apply that statute to the extent it is consistent with the Constitution, regardless of what the statute says, and regardless of whether I like how it addresses the subject, because that's the work of the court.
Let me follow up, if I can, briefly on something else, and that is the Code of Judicial Conduct. When you look at these campaign ads and comments made by you and your opponent, either for or against, the Judicial Code says a judge, candidate for judicial office, or judge-elect should not manifest bias or prejudice inappropriate to the judicial office. Every judge, candidate for judicial office, or judge-elect should always bear in mind the need for scrupulous adherence to the rules of fair play. Do you think the Code of Conduct has been broken in this campaign?
Well, that's a great question, and unfortunately, I'm going to have to decline an answer because it is possible that question, with respect to my opponent, will come before the Supreme Court for resolution. I don't intend to recuse myself from that matter.
Do you think anything on your side has crossed that line as well?
No, not a thing.
This is the most expensive election in any state Supreme Courts in the country. And there will be future elections like this here in the state and across the country. And seeing how it has been playing out through the news and how people have been pursuing this and other interest groups pouring in money in this. I guess, what's your view of how the landscape has changed since 2016 when you were first appointed to now, and your thoughts on where this is going to go in the future? Even though there is a resistance to involve the politics in this, it doesn't happen in a vacuum. What are your thoughts of how that landscape has changed and where it's going?
Yeah. So I've been told the eyes of a nation are upon us as we approach April 4th, and if the spending is any indication of that, that's certainly true. So my first response is, I think the nation needs to get out a little bit more. I mean, this is a Wisconsin matter. We can take care of Wisconsin business here. But having said that, there are those who care a great deal about how this question is going to get resolved. Because the way I framed it in my remarks is the way this is being viewed around the country. Will we have the continuation of the rule of law, or will we instead have the rule of Janus? Is there enough room on the Supreme Court for the Constitution and my opponent? Now, the reason that I think others from around the country are paying so close attention to this and why they're involved is because there's a fair amount of concern about what might occur if my opponent's template works. The people might pick that up and try to use that in other courts around the country to drive courts away from their constitutionally prescribed duties and into a role that is more akin to a legislature. So the question truly is larger than the state of Wisconsin. And I think that's what's driving the funding. Now, whether I like it or not, that's what it is. And, this is one of the reasons the First Amendment is where it is to make sure that we can have a robust conversation about these issues. Now, I say that knowing full well that at least at this point, I'm being outspent 2-1. But the principle does not change. We must have a free and open debate on these questions. And then the people of Wisconsin will make up their own minds. And I think that's one of the most important pieces to recognize here. In my estimation, as I watch my opponent run her campaign and how focused she is on politics, setting herself above the law, in my estimation, she's not qualified to be on the Supreme Court. But that's my estimation. At the end of the day, that doesn't amount to a hill of beans, because it's your estimation that matters, and the rest of our fellow Wisconsinites. So all the authority to create and maintain governments in the state of Wisconsin belongs to we the people, right? That's what the preamble to our Constitution says. It belongs to you. All the power to decide who sits in the seats created by that Constitution belongs to you. That's an enormous amount of power. Now, I've learned from Spider-Man movies that with great power comes great responsibility. And so as I look at this relationship that the Constitution sets up between you and me, makes you the bosses, me the servant. And I know full well that servants don't tell bosses what to do. I won't even tell you who to vote for. This is your responsibility to figure out. You need to take a look at each of the candidates and decide who will best serve you on this seat on the Wisconsin Supreme Court. That's your responsibility. And then beyond that, it's your responsibility to make sure that it happens, whichever way that it is. Now, I hope that analysis leads you to me. But whatever your decision is, it's your responsibility to make sure that decision happens. Talking to your friends, your family, your colleagues, helping them understand the stakes of the election and why it's so important. At the end of the day, it's about us as Wisconsinites. It's not about the money that comes in from out of state. It's about we as Wisconsinites deciding who the best servant will be on the Supreme Court.
You said previously that your politics won't interfere with your role on the Supreme Court, but you were paid $120,000 by Republicans for work over the last few years on election issues. You worked on the fake elector case. So how can you stay independent?
Yeah. So the Republican Party was one of my clients. I'm a lawyer. We have clients. Now, here's the thing about lawyers and clients. Lawyers don't pick up on the politics of their clients. I've had numerous clients over the years. I don't pick up on any of their politics. I don't make their politics my own. It is a practical impossibility even to do that, because I've represented people from all across the political spectrum. They came to me because they saw in me a good lawyer. And I understand that that's why all of my clients came to me. Not because of my politics, not because they might match or not match, but because I was a good lawyer. And just as a side note, really was not involved in the fake electors matter. I know that there have been stories out there that are actually internally wildly inconsistent. So on the one hand, they'll note that I was called once about this issue, maybe a half-hour conversation. And in the same article, it notes that when asked if I was in the loop on that question, I was not. And yet the article goes on to say that I was at the center of the whole thing. I'm not sure how that's supposed to work, how you can be not in the loop and at the center of the whole thing simultaneously. And of course, the answer is you can't.
How do you feel personally about the fake electors issue?
I feel that the law should be applied and followed by everyone all the time.
At a recent event, I believe up north, you made the comment that I would spend every single dollar refuting those ads. I think we're up to about $27 million WisPolitics reporting that's been spent in campaign ads. But you have not spent a single dollar yet on TV ads. Why not?
Not yet. So as it turns out, ads are expensive, and we've got a lot to talk about. And our fundraising has been very satisfying, but it's taken a little while to get the funds to do it. So those will be coming, and we will respond to them.
When you look at the dollars being thrown into this race, 27 million, do you think it opens the door for a conversation around judicial appointments versus electing judges?
Yeah, I think there's always room for that conversation. And this is one of the things that I think is critical and beautiful about our form of government. So right now, judicial elections are provided for by the Wisconsin Constitution. Now I know that we in the judiciary, we don't have any authority to change that document. Same thing with the United States Constitution. So the United States Constitution, Article 5 there, is there to amend the document. In the Wisconsin Constitution, it's Article 12. I've looked at both of those provisions real carefully, and it assigns zero role whatsoever to the court in changing those documents. And so if we are to have a change in the way that the judiciary is composed, that will have to come from a conversation between the people of Wisconsin and their legislators. And they know how to do this, right? Wisconsin Constitution has been amended numerous times. And so if it comes to the point where Wisconsinites are no longer comfortable with the idea of electing the judiciary, and perhaps this massive amount of spending will cause them to question this method. There are other methodologies that exist to staff up the judiciary. And perhaps that conversation will start, and maybe this election will be the impetus for that conversation to begin here in Wisconsin. But the one thing I know is that the people of Wisconsin, when they put their heads together, they do a pretty good job of coming up with wise resolutions. So if they decide this is something to address, I will sit back and watch and listen, and I'll be confident that the conclusion will come from some folks that have the best interests of the state in mind, and the best interests of all of our fellow Wisconsinites. And I see my host approaching, which must mean that I'm done.
Not yet.
Oh, good,
Not yet.
okay.
So I'd just like to thank our journalists, Victor, Corey, and Charles, for your questions. And now it's your turn. So if you have a question, there's a microphone here in front. So please step forward and ask your questions. You're not done yet.
All right, perfect.
Steve Schuster with Wisconsin Law Journal. You mentioned earlier that the Republican Party was one of your clients. Historically, Republicans have been very laissez-faire, hands-off with regulation on guns, environment, railway safety, and other things. My question is, when it comes to abortion, why is that an exception? And why should someone in Madison or in Washington, D.C. Be able to regulate such a personal decision for a woman?
Yeah, it's a great question. And I think there are some folks that you could ask about it that would probably give you a pretty good answer. But out of all the folks that might give you a good answer, it doesn't include me. You need to talk to some legislators about that.
Thank you.
Hmm?
Good afternoon.
Good afternoon.
So you spent your opening statement talking about the other candidate. You told, as someone who don't know you, who are you and what are you about?
Oh, splendid. Oh, thank you so much for that. So just a couple of moments, and I'll try not to take our remaining time on this. So I came to the state of Wisconsin 40 years ago. I spent most of my growing up years in Colorado and trying to figure out ways that I could afford to go to college. And lo and behold, a recruiter from Carroll College, it was college then, it's university now, came out to Denver, called me up, and said I'd like to meet with her. So I did and went and met with her, and she painted a lovely picture of Carroll College. And then the really key point, she laid out how I could actually afford to go to college. And so I'd never been to Wisconsin before, didn't know a soul here, but I came on out when I was 18, and I, on the very first day I was here, the very first people that I met caused me to fall in love with the people of Wisconsin. So I came out a little bit early to fish because I love fishing. And I was at a park in Waukesha County, and it was a beautiful weekend. Apparently the rest of Wisconsin thought so too, because y'all were there. I think I recognized some of you from that weekend. It was crowded, and all the campsites were taken. And through one thing and another, I ended up sharing a campsite with a young family from Sheboygan Falls. And they were such a lovely family. They spent essentially a long weekend teaching me what it means to be a Wisconsinite. And what I learned from that is that Wisconsinites are the people of the open hand and generous heart. 40 years later, I still find them to be the same. And I've had just a blessed life here amongst the great folks of Wisconsin. We have, my wife and I, we have 5 children who are mostly all grown now. My youngest is 16. She's the only one under 18 now. And I have enjoyed a long, long career in the law, something that I'd wanted to do since I was in 7th grade. Now, that might make me out to be a law nerd, but I will own that label. I've loved the law, partly, I think, because my parents instilled in me a deep sense of justice, that we must pursue justice. That justice is what allows us to live together in society in peace and with a chance of prosperity. And so as I've gone through my legal career, that has always been the watchword for me, is to pursue justice. Because that is the foundation that all of this rests on, without which we can't live together in society in peace and prosperity. And so I spent most of that career at one of the oldest and largest law firms in the state of Wisconsin. I did commercial litigation. I had the honor to help lead the Corrinne Family Foundation for a while, and then I started my own law firm. And that's always an adventure. When you start a new thing and put your own name on it, that's pretty exciting. And then, of course, I had the opportunity to be appointed to the Supreme Court in 2016. So now, as we approach April 4th, I'm hopeful that the good folks of Wisconsin will invite me to return to serve them once again as one of their justices. Thank you for that question.
Hello, Justice Kelly. My name is Ethan Duran. I'm with the Daily Reporter in Milwaukee, Wisconsin. Last week, Michigan's House voted to repeal their right to work law. Wisconsin has had a right to work law since 2015, introduced under Governor Scott Walker. If the issue came to court, how would you be trusted to handle it impartially, given your association with the former governor?
Sure. And by that, do you mean if the Wisconsin legislature repealed that statute?
In that scenario, sure, yes.
Well, if the legislature repeals the statute, then as a jurist, I would no longer apply it.
Steve Marsh here. Thoreau once famously said, "I may not agree with what you have to say, but I will defend to the death your right to say it."
Yep.
Shouldn't that apply to voting? I may not
Apply to
agree with whom you vote, but I will defend to the death your right to vote the way you wish. But the Republicans have gerrymandered every district in the state to favor their party. Can you do anything about changing that?
Not in the courts. So if the matter comes before the court, all we address are the legal questions, right? So when we talk about gerrymandering, what we're talking about is that we don't agree, we, the people of Wisconsin, we don't agree with the political decisions that went into creating the map the way that it is. And so just as with every other matter, if there are political objections to the map, those need to be addressed in the legislature. If there are legal objections to the map, those are things that we can address in the court. But as far as whether the maps represent a fair representation politically of the state, entirely a matter for the legislature.
Thanks for being here. You've gotten some flack about your Republican client, or Republican Party client. Today you shared that you've had clients from all across the political spectrum. Can you share some of those from the left?
Yeah, no. Here's why. So I'm aware of the climate that we currently operate in, and I've watched as individuals and organizations have been pilloried because of their association with candidates that some person or group or sector of the electorate doesn't like. And so one of the, as I was practicing law, one of my commitments to my clients was utmost discretion. And so I would never even mention who my clients were unless they asked me to. And I'm going to carry that forward now too.
Hi, James Davies. Thank you for being here. Don't you think it's a little a bit of an oversimplification, your dichotomy between political and legal questions? And just as an example, on both sides, the Lochner Court struck down a lot of labor laws on the basis of the liberty in the 14th Amendment, and the Roe v. Wade Court said abortion was illegal based on the penumbra of privacy in the Constitution. So these are both decided using legal reasoning, however much you agree or disagree with it. And a lot of us would argue that those are political questions. So what are your thoughts on that division and maybe a bit of an oversimplification of how the issues are actually decided?
Yeah, I don't think it's an oversimplification at all. And here's why. The nature of law requires that it be clear and accessible before you go to court, right? That's what the rule of law is all about. It tells all of us in Wisconsin that we can know what the law requires before we make our decisions. Now, if you have to wait until years later when a case winds its way up to the Supreme Court, and then you have a jurist create something that is not part of the plain meaning of the statutes or the original public meaning of the Constitution, then what you've done is you've robbed that person of the rule of law. Because unless you could foresee from the text of the statute, from the text of the Constitution, that this is what is allowed or prohibited, then what you're doing is you're making up a law at the end of the road and then applying it backwards. And that kills the rule of law. And that's one of the reasons why we don't do politics in the courts, is because the politics go to creating law, not applying it. So the obligation of the court is to take that plain meaning of the statutes, the original public meaning of the constitutions, and apply it as written, without flourishes, without originality. I've often said, and my campaign hates it when I say this, but I'll say it again, I am running to be the most boring Supreme Court justice in the history of the country. Because the role of the court is not to be original. It's not to be innovative. It is to do one thing: use the law as it exists to resolve the cases that come before the court. And that's what you do today. And then you come into chambers tomorrow, and your job is to use the existing law to resolve the case that came before the court. And then the next day you walk into chambers and it's still the same job. And on and on and on, ad infinitum. This is how we gain confidence as a people that the courts are resolving cases according to law and not political views. Thanks.
Thank you, Justice Kelly, for coming out and speaking with us today and answering questions. We appreciate it. Special thank you to Wisconsin Eye for streaming today's program, and to our partners at the Milwaukee Press Club and at WisPolitics for co-hosting. A few quick reminders. Don't forget to check your email and fill out today's program survey. Program committee reviews the surveys carefully, and your feedback helps to keep the quality of our programs strong. It takes just a minute to complete the survey. Our Rotary social event at the Explorium Brew Pub in the 3rd Ward has been rescheduled to Wednesday, March 22nd from 5 to 7 p.m. There is no need to RSVP. We hope that you can attend. Next week, we will hear from Major General Brian Winsky on the 20th anniversary of the March-April 2003 invasion of Iraq, with a particular emphasis on the 101st Airborne Division, where he was serving at the time. If you know someone who would enjoy visiting Rotary, please bring them along. There is no charge to bring along a prospective member. Now, let's go out and do some good in the world. This meeting is adjourned. Thanks. Yeah.